they had not attached anything to their lawsuit, thinking, what do I care? It's gonna get defaulted. Well, so I went hard in on them. So I started the case with the motion to dismiss, and now we went all the way to trial. And because of that motion to dismiss, they actually put their stuff on and I destroyed their witnesses and all their evidence. So why would LVNV funding do what it did? Suddenly change course and claim in its complaint one thing, and at the end where they go to trial, another thing. Well, here it is. Hey, Brian Parker here with another exciting video. Exciting because I'm glad to be back in front of the camera, which is a rare thing, but I just got done with a trial, a successful trial against LVNV funding up in Michigan in the circuit court, which is where everything above $25,000 is brought, and my client is very happy with the outcome. Before I get started, I haven't done a video in a couple of days because of this trial, because of the prep involved, because of I'm worn out. But I just want to get in front of the camera while the stuff is still fresh. I'm not fresh, but the ideas are. Like, love, and subscribe. Killdebt.com with ParkerGPT. 2.0 is coming. Hopefully by the end of this month, we'll have the 2.0, and there's some really cool things that are going to be added to it. The prices are going to stay the same, especially if you're with us now. But this thing I was looking at, it's a briefcase. You get your own little briefcase, and anything you do on the site goes into your briefcase. So you don't have to worry about losing searches or chats or videos you looked at. I gotta go find that video because I got 485 on there. No, it's in your briefcase. So some really cool things for 2.0 very quickly is on the way. Attached to this video will be one document, will be the actual trial brief I used in the court in the trial I just did yesterday. I did it yesterday. So I have a great story to tell you about the importance of the motion to dismiss. As you know, I just did a video that specifically says, what do? Do you do an answer or do you do a motion to dismiss? And my argument is do the motion to dismiss, and here's why. So check that video out. In this case, because we did the motion to dismiss, so you do a motion to dismiss, or in the alternative, Your Honor, I'd like you to make them produce lots of documents because as it stands, they got no proof, so give me a dismissal. He's gonna probably say no, but Parker, I'll make them give you documents. So that's what I did, and documents they were made to give me, they did. And that's the fun part of this trial. So I just did the trial of the case, I did the motion to dismiss. So I started the case with the motion to dismiss, and now we went all the way to trial. And because of that motion to dismiss, I was left very happy at the end of the trial. They actually put their stuff on and I destroyed their witnesses and all their evidence. So they quickly came to me, and before the judges made a decision, let's just say everybody's happy. So I started the case on February 25th, and started meaning they filed their first document of a lawsuit, and there it is, Shazam. That's the complaint. I want you to emphasize number 2, and number 2 says defendant entered into a contract with SoFi Bank NA. Stay with me. Remember I said February 25th, 2025, and they say that, hey, we got this debt from SoFi Bank. And then they went, and by the way, the next documents I'm going to show you came from my pushing them with the motion to dismiss. So, and documents they sent me, Shazam, that's the bank agreement, and it says right there, lender, SoFi Bank NA, meaning that's who is the creditor, the original creditor. It's called the originator of the loan. And we use the words originator because that's part of the securitization process. And you can see from the government mandated TILA Act disclosure form, Shazam, that says SoFi Bank NA is the creditor. So what's the problem there? Let's keep going. You're gonna have fun with this. So we asked for a validation, and the law firm representing LVNV funding sent us this, Shazam, and that's May 13th, 2025. And you can see SoFi Bank is the original creditor. And also the account was opened September 25th, 2023. And that is important because if we just go back to the disclosure form, Shazam. You can see the debt was actually opened September 24th and not the 25th. So that may seem like a small thing. In the trial, the judge saw that and said, out. There are documents that they brought in that all said the 25th that supposedly were done by a custodian of records with personal knowledge. Remember, nothing comes in because it's all hearsay, but 803.6 is the business record exception. That's how debt collectors are getting everything in. You've seen my videos. You can see the video I just did on the 902.11 submission of documents. There it is. And that is, nothing comes in unless it comes through the business records exception. So they're saying, the law firm is saying, hey, it's SoFi Bank and the account was opened on the 25th. It wasn't. It was opened on the 24th. So anyway, I used that. Believe me, I used everything. So the last thing that they filed with the court. So remember, let's just put up there the first thing they filed, Shazam, number 2, and that was February 25th. This bank, this debt was created by SoFi Bank and subsequently transferred to plaintiff, which is LVNV funding. The last thing they said, SoFi Bank NA services loans that originate from SoFi Personal Loan Trust 23. So they went from saying SoFi Bank is the originator to now they're just servicing. Anybody can service, right? You don't own a debt, you can't sell the debt. So now for some strange reason, they're claiming SoFi Bank is a servicer and the original creditor is personal loan. And they doubled down in this in their evidence and trial brief, Shazam. Summarily, SoFi Bank, SoFi Personal Loan Trust 2023 is the original creditor. You just saw the actual paperwork that says SoFi Bank is. They're now claiming into the court several months later. Despite what the evidence and the law and the original creditor says, they're not the original creditor. A trust is, a securitized trust is the original creditor. Why would they do that? Well, they tripled down. I don't know if you can triple down. I know you can double down. So they tripled down and attached an affidavit to a summary disposition. So remember, I filed a motion to dismiss saying there's no documents. They came back with their response and they filed a motion to dismiss against my client and with this great affidavit, right? So let's put it up there, Shazam. First of all, it's 1, 2, 2, then 3. And in this affidavit, I don't know if you want to spend the time, there's nothing mentioned about SoFi Bank. So client gets a debt and a loan from SoFi Bank, it's out there, you can do that. But in the affidavit, there's nothing mentioned about SoFi Bank. How do they go from saying SoFi Bank gave this to my client to a sworn under oath affidavit? It says at number 2, SoFi Personal Loan Trust 2023 transferred all rights and title and interest to my client's loan to Resurgent, which, you know, if you know anything about LVNV funding, now Resurgent is handing that to LVNV funding. Sorry, again, I'm fried from trying cases and flying in planes. So the first thing is to notice the 2 things of that affidavit. Let me put it up there again. Supplemental affidavit in support of plaintiff's motion. That suddenly showed up in trial and the judge said, this is for summary disposition. This is a trial, but I digress. Shazam, there's that affidavit again. Notice there's no mention of the original creditor. See paragraph 2, which says, SoFi Personal Loan Trust 2023 transferred all these rights. So weirdly, LVNV funding again stated in its brief, Shazam, essentially SoFi Bank NA, a seller and servicer to Resurgent, sent the debt to Resurgent, who then said it to LVNV funding, we only have 2 assignments. You're gonna see how weird that is. It's in their paperwork, even though they just said there is no SoFi Bank, after saying, yes, there is a SoFi Bank. So here's another affidavit they filed. They're just chock full of affidavits on the same date. Remember that? Let me put up that validation response from their law firm for May 13th. Shazam. That's the Roussin Vercetti Olivier, May 13th. Original creditor, SoFi Bank. account was opened September 25th. Now they came up on the same day with another, this one's from LVNV Funding, a witness swearing under oath, Shazam. And you can see from number 3, she's saying she has personal knowledge. So in order for this to be taken seriously under the hearsay exception to hearsay, with the business records exception, she's got to say, I have complete personal knowledge, I handle all the documents, for it to be taken as truthful. And she says the account was originated on September 25th, 2023. So if she had knowledge of the documents, she'd hold the most important document, which they brought in the trial as Exhibit 1, which is the loan agreement. We all signed a loan agreement, and the creditor was SoFi Bank, and the federal disclosure form that you have to give a debtor showing exactly how the payments are going to be made, how much the interest is going to be charged, and what's the total amount, says September 24th. So if she's familiar with these documents, she would know it would be September 24th. Think that's no big deal? Judge did, threw this out and threw out the evidence because they should know their own documents if they have personal knowledge. The judge was cool. The business record exception, it's very complicated. I've read it 600 times, and there's still stuff that I'm like, oh, and the judge broke it down because it's tough to apply. And he essentially said the first part of the business records exception was the most important part, which says you've got to have personal knowledge or you receive this from someone with personal knowledge. And I'm going to show you why that's so hard to believe that anybody could have personal knowledge of this. But they certainly didn't if they got the date of the actual loan wrong. But they go to great pains, let me just put that there, 3 and 4, to say that SoFi Personal Loan was one of the owners. They're really moving away from SoFi Bank. As I'm saying this, yeah, they said SoFi Bank, but they said the wrong date. So why would LVNV Funding dump its actual lawsuit? You can't sue anybody without a complaint. Their actual lawsuit says SoFi Bank is the original creditor that gave it to LVNV Funding, but they didn't end the case that way. Suddenly SoFi Personal Loan Trust 2023-1, which, as you know, that's the markings of securitization. Most of these SoFi, in fact, all of them. In fact, if you're lucky enough, if you have a loan agreement from SoFi Bank, I don't know if they still do it, but they used to actually say in the first page, bottom left, they would say, we securitize our debts, which is really helpful because when someone says this wasn't securitized, but it says it right in the loan agreement. So why would LVNV Funding do what it did? Suddenly change course and claim in its complaint one thing, and at the end where they go to trial, another thing. Well, here it is. They didn't expect to be challenged. Remember we talked about the 9 out of 10 rule? Up to 9 out of 10 cases are gonna end in default. And if you don't answer the complaint, that's horrible consequences. You get a default judgment against you that in some states can stick around for 20 years. So they didn't expect to be challenged because they know it's easy peasy, nobody's gonna answer. Well, I did, my client did. So they had not attached anything to their lawsuit, thinking, what do I care? It's gonna get defaulted. Well, so I went hard in on them, but my client was cool. I'm gonna give you a little tip now. I have been where you are. I've been there, I've been through everything. You name it, I've gone through it. You throw stuff away, you get tired of the bills, you get tired of this. I got work to do, I just want to put this over there, I don't want to think about it. My client kept the letters that he received, and before the lawsuit was filed, this letter came from Resurgent. Remember, Resurgent is the collecting arm for LVNV Funding. So Shazam that letter, and in that letter, they said, hey, we're collecting for SoFi Personal Loan Trust 2023-1. That's a weird admission because they don't want to get into the securitization. I think someone made a mistake, and you're going to see there's a couple of mistakes in this case that they did. You wouldn't say you were representing a trust. Because at that point, by the way, that's October 9th, 2024, supposedly the thing had got transferred to a whole bunch of entities that eventually ended up with LVNV funding. So none of that did not make sense to me, but here's this silly letter. We kept it, and I filed the motion to dismiss saying, hey, they say it's SoFi Bank. This letter says they're collecting for a securitized trust. Therefore, it's securitized. Therefore, they have to show an assignment to whoever now owns the debt. So they came back, and this is what, so remember again, 9 out of 10 people are going to default. So they just file crap, generally debt buyers. But if you push, now they got to justify the crap. These guys kind of went one step further and relied upon what I had showed them to go, uh-oh, we better show everything emanating from SoFi personal loan. And let's say, yeah, it was securitized. Whee! Now we have it, even though none of their paperwork originally said that there was a securitized trust, but I digress. And they handed us 2 bill of sales. One, Shazam, closing date September 26. SoFi Bank is selling something to somebody to Resurgent Acquisitions. And I'm not gonna go deep because I'm gonna do another video on this. It'll be a fun video. Then somebody again made a mistake. So there is really no LVNV funding per se. It's just an entity that they use to buy stuff. The servicing branch is a bunch of, there's about 4 or 5 Resurgent Acquisitions, Resurgent Services, Resurgent this, Resurgent that, and they are the servicing arm. They do all the work. They do all the collecting on behalf of LVNV funding. But the lawyer doesn't put everything together that's suing. He makes a call or does an email down to Resurgent and says, yep, we need XYZ. Well, they gave him XYZ plus, and they sent up, well, let me show you this first. So, sorry, I didn't show you this. This Shazam, here's a list of a ton of trusts that were in this first bill of sale, SoFi Bank NA, supposedly sold to Resurgent Acquisitions September 26. And you can see all the personal loan trusts. Well, they say, see, we own the debt and we own SoFi Loan Trust the debt. So my first question is, which one of these has my client's debt? Nobody could answer that at trial, and they just hem and they haw. And here's a tip. I'm gonna tell you about this tip in another video, but when they start looking at their attorney for help, you know you got them, because they're like, oh, so I've done trials for 30 years. As soon as they look at the attorney, I do this. I go, don't look at her, look at me. Now that sounds kind of rude, but what I'm doing is I'm telling the court, she's not talking from her memory or from her records. She's looking for the answer for the guy that put her up on the stand. So that may sound rude, but it's alerting the court, uh-oh, she doesn't know the answer to this. So there's all these tricks you do. So someone goofed up, as I said, and they gave us another bill of sale from the same date, Shazam, and that's showing SoFi Lending Corp. Okay? Where the hell did that come from? All of a sudden, SoFi Lending Corp on the same day has something to give to Resurgent. So my question to the poor person on the stand that I just grilled and barbecued and shish kebabbed, and it was very nice, but it was surgical. So how does somebody, SoFi Lending Corp, give something to Resurgent if SoFi Bank gave something to Resurgent? Which one had my client's debt on the same day at the same time? But I digress. So that's why you do the motion to dismiss, because all this stuff comes out. You say, Judge, dismiss this case. The court doesn't really want to do that early, but you attach to the motion a motion for more alternate documents. And the judge will go, Parker, I'm not going to give you this, but I'll make them give you the documents. And again, they gave me all these great documents because they needed to prop up the fiction of the whole thing. SoFi Bank never gave anything subsequently to LVNV funding. There was a whole bunch of entities. There were 5. And let me put those up. Shazam, SoFi Bank, NA, SoFi Lending Corp. By the time they're giving me all this stuff. SoFi Personal Trust 2023-1, Resurgent Capital Services LP, LVNV Funding is all claiming to have owned and or sold the debt. So here's what it looks like at the beginning of the case. Shazam, number 2, defendant into a contract with SoFi Bank. So when they're done and I'm done grilling everybody, these things are true. Shazam, there's no assignment of the defendant's loan from SoFi Bank to SoFi Personal Loan Trust. There's no assignment of the defendant loan to SoFi Lending Corp. Remember, they goofed up and gave me a second one. There are 2 bills of sale for the same debt on the same day. Which one passed on my client's debt, and how did one SoFi Lending Corp get the debt with no assignment? And without any proof or above, there's no assignment of my client's loan to Resurgent Capital Services for it to give it to LVNV funding. It was just a complete, the truth you can tell in one sentence. Let me just put it that way. So they supplied this document, Shazam, on the same day. Apparently all these people at SoFi Bank and SoFi Lending Corp all signed, got together and signed. And what they said is, see, all those entities passed the debt, my client's debt, and gave it all the way to Resurgent and then to LVNV funding. Forgive me how I put this, but a blind man can see how bad this is. So without any proof, they failed to still show how SoFi Bank gave it to LVNV funding, which is their original allegations. So like, love, and subscribe. Go to Killdebt for all the supercharged AI power. You may not believe in AI, but it believes in you. And these debt collectors, you see my videos, are now going in hard with AI. It enables them to sue more people in a short amount of time with less employees. But for us, more mistakes. So use the AI-powered ParkerGPT to fight back against the AI debt collectors. They're coming. Just check your work before filing. We put in millions of cases to eliminate or try to eliminate the hallucinations that you'll see at ChatGPT or those other things. We've embedded the thing with just the debt defense. We're not making, don't go to us if you want to find out what's a good car to buy or a shampoo to use. But if you've got a lawsuit coming your way, ParkerGPT is the way to go. I got all the stuff you need right in the ParkerGPT. So this is a video. It started out being how I'm going to teach you how to do a trial brief. I will attach the trial brief. It will show everything I just said in the trial brief. I'll do it in Word so you can mix and match. That'll be my only attachment to this video. Interestingly, when I grilled, barbecued, you name it, surgically tore apart their poor custodian of records, I used my show notes. I had my show notes, and I just used my show notes and just massacred, I believe, their evidence. There's another video coming out on this trial, which will be really cool, on the bill of sales. I'm going to show you some really cool tricks. I want to tell you this one trick I did, but for the next video, how I got my client not to have to testify for them. I'll just leave it at that. I made it so they didn't even have to show at court by this weird rule that I went in and the judge was like, and couldn't do anything about it. I was just following the rules. So I saved my client having to be on the witness stand. So like, love, and subscribe. As I said, go get you some Killdebt.com and some ParkerGPT. It's the best thing you ever do if you're facing a collection lawsuit. Thank you. Bye-bye.